2018, Supreme Court gave a clear verdict that Sabarimala Temple will be thrown open to the menstruating women, and the entry which was banned, that will no longer be valid. But in 2026, Supreme Court is sitting with a 9-judge constitutional bench to review what was said, and the observations that are coming along are something very important for us to understand. Because when we look at the Sabarimala case, it is not just a case about entry of women, it is a case about constitutional questions, it is a case about fundamental rights and also religious rights. Hello everyone, welcome to Vajiram and Ravi's Flash News. My name is Shubhangi Singh, and in today's session we are going to discuss in detail the judicial observations that have specially come along in last 2 days. The first one that we will be talking about comes from Justice Nagarathna, and in this what she has said is that if we are throwing open the temples for everybody, and she is saying that when we talk about Article 2522B, it specifically talks about throwing open of only temples. This is a provision that is mentioned, and this is only because that a system such as caste system is mentioned, is associated broadly with Hinduism, not other religions. Another judicial observation that has come today is about the fact that we have to understand and make sure that individual rights are not arising, the individual needs are not arising so much that will lead to annihilation of the religion. And in this context, Justice Nagarathna has again said that when we are talking about true devotees, who are women between 10 to 50 years, they can observe the restraint and they can go and visit the temple after 50 years of age. Now, when we look at both of these observations, as I mentioned, this is coming along when this whole 9-judge constitutional bench is reviewing the Sabarimala verdict that came in 2018. And in this context, it is the debate about temple entry versus religious autonomy. Now, when we want to understand this better and in deeper detail, the first thing that we need to understand here is that what are the constitutional provisions around it, what is the constitutional framework that is guiding this judicial observation and also the debate which is present here. So, we have to start with, of course, Article 25. Article 25, when we are talking about the first judicial observation, in that reference, Article 25 is about freedom of religion. That is an individual right, but this right is not absolute. So, in this context, we also have to understand Article 25(2)(b), which gives the exception to religious freedom for what? For equality. And in this context, Article 25(2)(b) allows the state that it can open Hindu temples to all classes, and it can bring in social reforms. And in this context, multiple such legislations have been brought on. And in reference to the second observation that we have made, we also have to understand the constitutional provision around it. In that context, we again have to understand that when we are talking about religious freedom, it is subject to public order, morality and health. And that is why courts also remain very cautious in deciding the religious matter. Apart from that, the first observation when we are talking about Article 25 and 26, they come in confrontation of each other. That one person is allowed to individually have the freedom to practice his own religion. But what about right of the whole group, right of the whole denomination? So, when we have established the constitutional provisions, now let us move to understand that what exactly has been said. The first judicial observation has been of the fact that when we are talking about Article 25(2)(b), it applies only to Hindu institutions. That has been clarified. The reason has been explained is that when we are looking at caste-based exclusion historically, we clearly get to see that it has existed in Hindu society. This is what Justice Nagarathna has explained. And constitution makers were aware of this reality. That is why when we are talking about Article 25(2)(b), it enables the opening of temple entries, not any other religious institution. And that is why we get to see that no other religion has been mentioned, because this exclusion was not historically prevalent in any other religion. And when we are looking towards the other judicial observation, this is where you have to understand that customs have evolved over time. So this is where the denomination rights, Article 27 comes into prominence. This is the judicial observation, second one, which says that courts cannot hollow out and hammer out the religion in name of reform. That means when we are talking about individual rights, this is where courts have to be cautious as well. Courts have to also limit themselves, because it will lead to annihilation of the religion in itself. Final verdict has not been given. These are the judicial observations that have been made along the review. The final hearing is expected in May, and when we are looking at this, the judicial observation, we clearly get to understand that where the core legal conflict lies. And this legal conflict is the reason of actual debate, the reason we are discussing it here. The fact that equality, that means the individual right, is coming against the group, that is denominational right. Because when we are talking about Article 25 2b, it talks about social reform. But the problem here is it stands in exact contradiction with religious autonomy in multiple places. Article 25-22b will benefit individuals of all classes, yes, but Article 26 is there to protect the religious groups, and in this case, it seems it is this versus this. Nature of Article 25-2b is reformative, but Article 26 is about protecting the rights of the denomination, protecting the rights of the religion. And that is why this conflict has emerged. Can state in the name of this go and harm this? Can they change the practices which have existed for equality? And that is what in the second observation the court has identified as a risk. They have said this is a risk that if we focus too much on individual assertion, it will lead to breakdown of the religion in itself. So this is where I want to ask you that how this needs to be dealt. Because one important thing here when we are looking at essential practices of religion, this is something that court has also talked about. We will not go into the details of that today, but this is also something. So do you think that needs to be kept in regard, or what should be the way forward from here? What are your thoughts on this? Let me know in the comment section. Now, once we have understood the core legal conflict, this is where I would like to move ahead and also discuss and also bring in front of you that why are we talking about this? Why this matters so much? Because when we look at Indian secularism, something that is present not just in spirit but in terms of words as well in our preamble, we clearly see it that it is in form different from Western secularism. It has always kept a space for reform, and this is where we also get to see that there is no strict separation between state and religion. Rather, state respects all religion, treats them equally. That's what has been promised. But when we are looking at this layer, we also have to see there are times when the religion stifles the individual right, when the religion stands against justice and mostly gender justice. This is where another USP, another unique point of Indian secularism comes out, that the reform space has always been allowed. There has been selective intervention, but that intervention has varied across religion. So that also talks about biasness. Because in this case, when we look at the first judicial observation, a lot of questions are being raised that why specifically Hindu religion is being targeted. But these questions need to be asked when other verdicts are also given, especially against the practices of certain other religions as well. So in this context, this is going to define that how this verdict, when it comes out, that how Indian secularism is going to look like. And that is why the question in front of us, that when we are talking about non-believers, people who are not following the religion or who are not following the religious practice. For example, Sabarimala Temple requires that menstruating women cannot enter the temple. There will be a section of people who do not believe that. That means they are non-believers. So should they be allowed to challenge this religious practice based on certain ground? But when you look on from the other lens, they are the ones who want to practice their own religion. That is an individual right, and they can choose in the way they want to practice it. So this is a very pertinent question that lies as of now in front of Supreme Court, and hopefully once the verdict is out, a lot of clarity would be seen. But in coming time, we really expect that social practices and constitutional morality, whenever they stand in front of each other, there is a balanced way out rather than extreme confrontation, and without actually compromising the civilizational continuity that India is known for, that exists in India, but also not infringement of individual rights. What are your thoughts on this? Let me know in the comment section. I'll be leaving you here with a prelims practice question. Let me know the answer in the comment section. That was all. Thank you so much.